take place. And I may have shared this with a couple of you who are here as well, but the genesis behind this was when somebody was asked to leave the front steps and they went and laid down in the alley, and the trash truck came in to empty the dumpster and injured that same guy who was laying in the alley. The trash truck company and the mission and their insurance companies were pointing fingers at each other saying, no, we're not responsible, you're responsible. And so we really felt like it's important to define who is responsible when it comes to vendor relations, construction relations, all sorts of stuff. Sarah Gibson has been a fantastic partner. She's an expert in this stuff. And so in our conversation, that was the genesis behind the developing this roundtable discussion.
Wonderful. And John, that is a great introduction. So Sarah is a member of our Gallagher team. As many of you know, Gallagher is 39,000 strong globally. And one of Sarah's specialties is working with our clients, large and small, all over the country, helping them take advantage of the different risk management resources that we have. So Sarah, as I know you know, we have a tremendous breadth of different ministries on this call all over the country. Some of them are the one and only risk management person at their ministry. There's maybe 10 people on staff, and they're the person that says, whoa, 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 we just can't do this new thing. We got to think about this. On the other end of the spectrum, we have at least one attorney on this call. There are some of our larger ministries employ attorneys, and they are very aware of contractual liability. And the other thing I'll highlight is a lot of folks get services that are discounted from vendors, or vendors who are even for free. And so we want to sort of talk through that as well. So Sarah, I'm going to put this over to you. For those who didn't hear me mention it earlier, I am recording the meeting. If you could mute yourself and turn off your video to make the stream a little smaller, that would be great. But please do interrupt. If something Sarah is saying isn't clear, please interrupt. I'll watch the chat, or you can just unmute yourself. And finally, I'll send this out by email, but we are going to have a part B and part C follow-up to this. So this is just the beginning of what really is a pretty complex discussion. So that's enough for me. Sarah, thank you so much for joining us. Take it away.
Absolutely. Thanks, James, and thanks, John. And thank you for everyone who joined the call. I really appreciate the opportunity to talk with everyone about contractual risk transfer. One of my main jobs at Gallagher is to help nonprofit organizations prevent claims from occurring and appearing on their loss runs. And one of the best ways we can do that in terms of losses being caused by third parties and vendors that we're hiring on site is to transfer the risk to them, make sure that it's their responsibility. And unfortunately, just working over the years with various nonprofit organizations, not everyone is paying close attention to what goes into every agreement, or they're not reading every single agreement. And it's never a big deal until someone slips and falls and it was, caused by the vendor on site. And then at that point, we're playing catch up and looking through to see who's responsible. And a lot of times the contract with the vendor is going to outline who is responsible. And without that contract being in place and transferring the risk to them, it could end up falling on the organization. And as you guys know, religious and nonprofit organizations need the money that you guys have to actually go to the programs, go to the employees, go to the good service that you provide to the communities. And so the last thing we want is dollars being paid out of pocket or insurance premiums increasing because of claims that are being caused by third parties. So today's focus, like James mentioned, there's going to be 3 different series. One that's going to focus on construction agreements because that's its own beast. Another that's going to focus on liability waivers, participant waivers, volunteer waivers, and the like. But today's is going to be focused on vendors, contractors, subcontractors, whatever you want to call them. Essentially, if it's a third party coming on your site to do any type of work, whether it's actual physical work like maintenance, or whether it's a service provider that's maybe coming on to do counseling services for people that you provide services to. I'm just going to refer to them all as vendors under one umbrella. And really the goal for today is to have a discussion about risk transfer to vendors. And then when you do contract with vendors, what insurance you should be requiring in terms of coverages and limits, as well as other risk transfer wording that should be in the agreements. And like James said, we do want this to be an open discussion. So if you do have any questions, feel free to put them in the chat. I do have the chat up on my screen, or you can raise your hand or just unmute yourself and speak up. We want to make sure everything is understood. And again, if you have any lessons learned from your organization that you want to share with the group, that's fantastic. We'd love to hear it. Or again, if you have any questions or concerns that you want to raise, feel free to do it with that throughout the presentation. Okay. So first and foremost, just want to talk about vendor selection before we get into the contractual risk transfer, because a lot of times that's where it starts. Our best practice recommendations from an insurance perspective is, if you are going to do a job, do your best to get multiple proposals. I know that's a tough time to do right now because there are staffing shortages, there are just vendor shortages, people can't come out. So we are in a unique time in that aspect. So you may be having to work with companies that you wouldn't otherwise, or not be able to get multiple proposals. But if possible, we do recommend talking with multiple vendors to see what the scope of services is. And again, if you're contracting with one vendor or looking to enter an agreement with them, but they're not willing to accept risk, they want your organization to accept it all. It's good to have other vendors that you've talked to, that you can maybe understand their pricing and their willingness to negotiate, that you can have as a backup. We also recommend when contracting with vendors to make sure you talk through the expectations of what work they're going to perform, and then get that scope of work in the agreement. We've seen a lot of times where a vendor in an organization is talking, and as you guys know, there can be miscommunications and conversations. Someone says something and another person hears something totally different. So we just recommend making sure that you guys are on the same page with your vendors, and again, that everything is listed out in that contract in terms of their scope of work. I also recommend just checking the Better Business Bureau as well as the State Attorney General's office for the state that you're in, just to make sure that vendor does not have any significant complaints made against it, or potentially I've even seen some clients were going to hire a vendor. They checked the State Attorney General's office and found out that it should have been a professionally licensed vendor that had their license suspended. The vendor, of course, wasn't disclosing that. They were able to figure that out doing due diligence on the back end. So that's another thing we recommend looking before entering into contracts with vendors. And with that being said, it's always best practice to have a list of vendors before you need one, or at least have vetted some vendors. So for example, on the property side, you may not have had a leaking pipe yet, but that's something that very well could happen just by having a building. So being able to look ahead of time, see what water mitigation vendors, mold mitigation vendors are in the area, and doing that vetting ahead of time will help relieve some stress in an emergency situation when you do need someone. That way you know who you're calling is a good, reputable vendor, because as reputations for your organizations is an important aspect, and we certainly don't want a poor vendor, someone who comes in and does a bad job, or service provider to come in and affect your guys' reputation or your operation. So we want to make sure that everyone coming and working on site is someone who's going to be able to do their job and do it well. So with that being said about vendor selection, now we'll move into why everyone's actually here, which is the contractual risk transfer piece. And I do need to put out a big giant disclaimer that I'm not an attorney, and that nothing in this presentation is legal advice or any of our feedback. Everything that we're recommending today and talking about is coming from an insurance and claims perspective. So what I mean by that is we've seen insurance claims come in, and we've seen some that were caused by vendors that we were successfully able to transfer to vendors, others where we were not able to transfer it to the vendor, even though they caused the loss and the organization ended up having to pay out the claim. So we're taking lessons learned from all of those claims that we've seen from our clients from across the country, and we're pulling out best practices from that and recommendations from that based on what we've seen happen and play out in the real world. And a lot of the recommendations also come from our insurance carrier partners and the actual claim adjusters, who are the ones handling the claims. So like I mentioned earlier, when entering into an agreement with the vendor, it's very important to make sure that every single clause is being reviewed, or every section or paragraph would be another way to word that, because that agreement, like I said, may say who is responsible for a loss if it arises from the vendor's operations on your site. It is also going to say if there are insurance requirements, what insurance is required, how high those limits should be, and then whose insurance would be primary. So just because you are requiring a vendor to have insurance and you get proof of insurance for them, it may say somewhere in the contract that your insurance is actually primary, that theirs is non-contributory and only would sit excess after your insurance policies have paid out. The contracts can also, in those insurance requirements, give one party rights under the other party's policies. So, for example, if you're entering into a contract with a vendor and you're required to name them as an additional insured, they'll actually have rights under your policy, and if they cause a claim, would be able to file a claim directly with your insurance policy. And as you guys know, having claims on your loss runs will end up affecting insurance premiums in the future. So again, that's why it's so important. We want to make sure that that contract says who's responsible, what insurance needs to be in place, and then whose insurance is actually going to be primary and responsible for responding if a claim does occur. So before we really dive into the meat of it, I did just want to go over some key insurance and contract terms, just because the insurance industry, insurance policies love creating new words to describe things that they could describe in layman's terms. So to start off, there's three key terms when it comes to transferring risks and agreements, and that's the first three here, which is indemnification, hold harmless, and duty to defend. And a lot of times when people are reading through agreements and they see these different terms, they think they all mean the same thing, or it's just redundancy. But because of the way certain cases have played out in the courts, and from what we've seen when our insurance carrier partners tried to transfer claims to at-fault parties, they actually have very distinct definitions. So indemnification, or if someone's responsible for indemnifying you from a loss, it means they're accepting responsibility for all of the losses, and they have an obligation to pay you for those losses, for those damages. So that's what indemnification is. Hold harmless is essentially a release of liability. And then a duty to defend means that they actually have to also pay for your defense costs. There was, I don't remember the court case that it was, but the judge essentially ruled that indemnification meant they had to pay for the damages. So let's say someone gets hurt and they have medical expenses, they would have to pay for those. But it did not include defense expenses. So now when we are looking through these contracts, we want to make sure that the third party is required to indemnify you, so pay for those damages, defend you, pay for your legal expenses if there is a lawsuit, and then also hold you harmless from any liability, which would be important, and that you would not, it's codifying the fact that you're not responsible for any losses that they cause and potentially any losses that they incur. The next two words are more insurance policy terms. It's subrogate and tender. So subrogate, also sometimes called subrogation, refers to typically an insurance carrier recovering money they've already paid for losses from an at-fault party. So let's say a vendor comes on site, like the situation John mentioned, and they are driving a vehicle, they hit a person, that person files a lawsuit. We have a good agreement in place with them. They have adequate insurance. They've agreed to be responsible for the loss, so their insurance policy is responding. Now, if at the end of that claim, the insurance carrier decides, you know what, I think the building's responsible. They should have had better lighting, or they should have had a warning signage placed to warn that people may be there. Whatever it is they come up with, they can then subrogate and go after the organization, go after your insurance carrier to try and cover what they already paid. So just because you transferred it and they covered the claim doesn't mean it's necessarily going to stay that way, and they could potentially subrogate against you. But there are waiver of subrogation clauses in the contracts that you can put in there, which we'll go over later. So that way, okay, not only am I transferring the risk to you, but you you have waived your rights, you've waived your insurance carrier's rights to subrogate against us. That way we just have peace of mind that once a claim occurs, we know no one's going to be coming back after our organization or our insurance policy. The other risk transfer term in insurance is tender. And tendering a claim just means you're essentially transferring the responsibility of a claim from one party to another. So a lot of times if you submit a claim to your insurance carrier, they ask for a copy of the agreement with the party that caused the loss, and they see that you do have a good indemnification agreement, you do have protection under their insurance policies, they'll say, okay, we're going to tender this to the party. Another risk transfer term in insurance is additional insured. So I talked a little bit about that earlier. So there are some insurance policies where the first named insured can add an additional insured on their policy, and that additional insured has rights under the policy and is entitled to have claims paid for and covered by that policy if required by a written agreement. So that is a great risk transfer tool outside of just having a written agreement with the vendor. Is if you can become an additional insured on their policy, it can save a lot of headaches, because we know now that they have the policy in place, we know that you have coverage under their policy, we can file a claim directly with their policy, and that policy has to respond because you have rights under it. So it is an excellent tool, and we'll go over the proper language to use a little bit further to make sure that that's in place, as well as some of the common pitfalls with additional insured status, that just because the contract says you're an additional insured, there are some ways endorsements and insurance policies are worded to try and create loopholes so that the insurance carrier can deny coverage, but we're going to go over what those loopholes are and how to close them a little bit later on. And then finally, the last two terms I just wanted to go over are claims made and occurrence policy. So for those who aren't familiar with insurance policies, or maybe don't work with James and John as closely with placing the policies, there's really two main types: claims made and occurrence. Claims made means the policy is covering claims that are made during the policy period. So if your policy is running from January 1st, 2023 through December 31st, 2023, it'll cover any claim made during that policy period, regardless of when it's made. An occurrence policy covers claims that occurred during the policy period. So for example, if the slip and fall occurred in 2013, then the 2013 policy period would cover it. If it versus a claims made policy where it doesn't necessarily cover when the loss occurred, it covers it when the lawsuit is filed, when the claim's actually being made against you. So it comes into play for certain insurance policies that are claims made, because I know there's people here from across the country, but as most of you know, your state likely has a statute of limitations for different lawsuits, anywhere between 2-4 years, maybe more. Especially more for minors. A lot of times the statute of limitations is extended beyond their 18th birthday. So if someone is 8 years old and gets injured, they potentially have until their 20th or 21st birthday to file a lawsuit, depending on your state's laws. So if you do have a claims made policy, you want to make sure that you have special wording in the agreement that requires them to have an extended reporting period. And that way, if a claim is made after their operations are done, we know that their insurance policy will still cover. So I know I just threw a lot at you guys, and I apologize for throwing the insurance jargon down the fire hose at you. But like I said, I will go over all of this in more detail. I just didn't want to accidentally slip up and start using insurance terms, and you guys didn't have any context for what I was saying. Okay, so with that as the context, again, when we're entering into agreements, before you sign, the two key contract clauses that can transfer risk are the indemnification clause and then the insurance requirements clause. The indemnification clause is what's going to say, hey, you're responsible for the losses, you're holding our organization harmless, and you'll defend us if there's a lawsuit that gets filed. The insurance requirements sections is what says, okay, here's the insurance coverages that are required, the limits, the coverage attributes that we want to see, including the additional insured status. Those are the two main ones. Now, there are sometimes other liability clauses that vendors, we tend to see this a little bit more on the construction side, that they'll try and sneak in there that will say, our liability is limited to whatever the contract price was or the agreement price. So for example, if you were to pay $1,000 for vendor services, they'll try and put wording in there that says, our liability to you is capped at $1,000. So while the indemnification clause is important and the insurance requirements clause is important, it's equally as important to read through everything else in the agreement just to make sure that no language has been snuck in there that's going to try and limit the vendor's liability to a specific dollar amount. And then when entering into these agreements and working through those clauses, there are some common pitfalls that occur where, we think we have a good contract in place, but
Sarah, this is James. I'm going to interrupt you. So if you see a hey, we're limiting our liability to $1,000, should you say, no, I'm not going to sign it? Like, should you be pushing back on that? Is that our recommendation?
Yes, our recommendation is just to strike it out and to eliminate it entirely. If they won't eliminate it entirely, and this is a vendor that you do want to work with, that's when we recommend having a conversation with them to get an understanding of what it is they're trying to limit. Sometimes they have that in there and they're trying to limit it for a very specific claim, or sometimes it's not even for third-party claims at all. They just want to limit liability to potentially damages that the organization incurs. So it's good to get an understanding of why that's in there. And you can always reach out to James and John or myself directly. My email will be at the end of the slide. And we have sample language for different situations that could more specifically spell out the scope of what that limitation of liability is. Another thing that we sometimes do if they're just pushing back is in the indemnification section, we'll say that this particular section is not limited by any other provisions in the agreement, nor is it limited by the amount or type of insurance that the vendor's providing. And so that way, when they are required to indemnify you, that cap doesn't apply, but it maybe would apply for losses that occurred outside the scope of what they're required to indemnify you for.
Yeah, that's good feedback. Thank you.
Yeah, absolutely. So some of the common pitfalls we see are that the contract doesn't hold up in court. A lot of times what we see happening in these claims is that a judge will look at an agreement and say, okay, this and that does not comply with a state requirement, or it violates a state regulation on contractual risk transfer. So because that's in there, the agreement is now invalid and we're just going to throw it out. And we've actually seen claims where entire indemnification clauses have been thrown out by the judge because the indemnification exceeds what's allowed by state law. So that's one reason why it's a good idea to have attorneys review agreements, or, even if you don't have an attorney review every single agreement, maybe creating a template agreement that you use, or even just a template indemnification clause and have the attorney review it, because they're going to be most familiar with state laws. They're going to be up to date on different court cases and what's allowed and what isn't. So they can make sure that your contract is properly worded and isn't just going to be, thrown out by a judge if it goes in front of them. Another pitfall we see a lot that I did allude to earlier is the insurance requirements clause. When it spells out what we're requiring a vendor to have, it doesn't reflect changes that we see in common insurance policies. So when insurance carriers write insurance policies, a lot of them use what's called the standard ISO form. That's an independent organization that just writes template insurance policies that then the carriers take and either use word for word, or they tailor it, to their company, and then they issue the policy. And sometimes changes get made that greatly affect coverage that are, again, if you're not updating your contracts regularly, you may not have accounted for. So the most common example I'm seeing right now is that a few years ago, the additional insured endorsement was changed so that additional insured status only applies when required by a written agreement. And before, what people were doing were just getting certificates of insurance that said you're an additional insured, and that was kind of flying, and you were getting additional insured status. But now, if you're just getting a certificate of insurance that says you're an additional insured, if you don't have a written agreement requiring you to be an additional insured, it doesn't mean anything. It doesn't hold any weight. So those are the types of changes that we see a lot, which is also why, in conjunction with having your attorney review your agreements, it's almost equally as important to have your insurance team, in your guys' case, the Gallagher team, review your contracts to make sure that those insurance requirements are reflecting current policy language and that there's no loopholes that you guys might be falling trapped to. Another common pitfall we see with contractual risk transfer is organizations not requiring proof of insurance. Just because they sign the contract doesn't necessarily mean they're complying with it. And the only way for you to know for sure that they have the insurance in place and the coverages in place is to get proof of insurance. And then the last one that's on there is, people not requiring additional insured status on the general liability. Again, that's one of the best ways to ensure that you're going to be covered if the vendor causes a loss, is to make sure you're an additional insured and that's written in the agreement. So on this next slide here, I have a sample broad form indemnification clause. And what we mean by broad form indemnification clause is it's an indemnification clause that essentially requires the vendor that you're contracting with to cover you from any and all losses that are arising from the agreement, their operations, their use of your premises. It's all encompassing. This is, of course, ideal. We would love for everyone here in the Citygate network to, every time they enter into an agreement with a third party, have this broad form indemnification clause and get this protection. I know that, as James mentioned, that you guys do also work with vendors that are maybe providing discounted services or services for free, and they may not be comfortable with such a broad form indemnification clause since they're doing a favor for your organization. And that's okay. There are other indemnification clauses that we can have that doesn't necessarily say, oh, you're responsible for everything. We have sample language for indemnification clauses that say, okay, the vendor is going to indemnify you from losses arising from their negligent acts or omissions. So essentially they would have to do something wrong or be negligent, and their negligence contributed to the claim in order for it to apply, and not necessarily just any loss arising from their work. There can also be mutual indemnification clauses where they agree to indemnify you from losses caused by their negligent acts, and you agree to indemnify them from losses caused by your negligent acts. So if you or an employee at the organization contributed to a loss, you could agree to indemnify them. Now, that requires the organization accepting some risk, accepting some liability with the vendor's operations. But again, if you are contracting with a vendor that is in essence doing you a favor and you are getting a good deal and you want to go with them, there are ways that we can still make sure that you guys are protected to some extent, but maybe not to the greatest extent possible. So this isn't an end all be all, and we work all the time with organizations where we sort of change this language so that it works for all parties and enter some negotiation. But at the very least, we want to make sure that whoever it is that you're bringing on your site to do work, whether it's a vendor that you're paying full market rate for, or a vendor you're getting discounted service from, that they're at least holding your organization harmless, that they're at least accepting responsibility for claims caused by their negligence. And that's key, because even if they're doing you a favor, we don't want to end up being responsible for something that they caused. Now, maybe we're not going to require them to pay or defend us if a lawsuit gets filed, but we want to make sure that they still have insurance and that they're still going to be responsible for covering themselves, and we're not responsible for covering them. Now, in the broad form, so in the indemnification arrangement where they're covering everything, some key language we recommend including, just to avoid some of those common pitfalls, is starting it off by saying to the fullest extent permitted by law. And that way, if it does come in front of the judge, they don't say, oh, you exceeded what's allowed by state law. Putting this at the front sets those parameters so that we're only asking them to indemnify us to the extent allowed by state law. And also, we recommend in the indemnification clause, regardless of whether it's a broad form or limited, we recommend putting in language that says the indemnification extends to claims occurring during the agreement as well as after the agreement is terminated. And again, that's because of the statute of limitation issues. The way some indemnification clauses are worded, they only apply when the agreement is current. So while they're there, doing the job, or if you have a master agreement with a vendor, it may only apply as long as that agreement is valid. So we want to make sure that this indemnification doesn't just apply when the agreement is still in force. We want to make sure it also applies after that agreement is terminated, because again, claims can come years. Sometimes I've seen even a decade after the incident occurs. So we want to make sure that that protection extends there as well. Now, most states do not allow one party to indemnify another if the loss was caused by the other party's sole negligence. So, for example, if a vendor's on site and a loss arises while they're working there from their operations, but an employee was solely responsible for causing it, most states do not allow the vendor to indemnify you in that circumstance. So just to make sure that the indemnification clause is compliant with state laws, there is language you can add in there that says, hey, this applies even if caused by, our ordinary negligence, but if the loss is caused by our sole negligence, the vendor's not required to indemnify us or any party. So that language is in there again, just to avoid the issue of the judge potentially throwing out an indemnification clause. And then, so to James's point earlier about, if there's a limitation of liability clause in there, what do we do? How do we make sure that the indemnification clause supersedes that? That's where this recommended language at the end comes in, where, it just says the indemnity set forth here in this section, it should not be limited by any provision of this agreement, nor should it be limited by the amount or type of insurance to be required by the agreement. Because sometimes the way agreements are worded, the vendor will come back and say, well, you require general liability insurance, but this claim is actually excluded under that. It would be covered by a different policy, but you do not require us to have that. So, we don't have to be responsible anymore. We don't have any insurance to cover this. So adding that language at the end just says, hey, regardless of what else is in this agreement, this is the section that supersedes everything else. Okay. Sorry, guys, I was just checking the chat to make sure there aren't any questions, but okay, perfect. We're good to go. So now we'll move on to the different types of insurance coverages and limits that we recommend requiring. What we see on this slide here is the big three. And we say that because most every vendor, no matter what they do, there is going to be some risk while they're performing services for your organization that they could cause someone bodily injury or cause someone's property to get damaged. They are most likely going to be driving a vehicle on your premises. If your if your buildings have a parking garage, if they have a parking lot, and they're driving vehicles on there, whether they're dropping supplies off or they're just driving there, they're most likely going to have some type of vehicle insurance. And then also most likely they're going to have employees, which is where the workers' compensation insurance comes into play. So general liability is what's going to cover third-party bodily injury and property damage. And we want to make sure they have that insurance in place so that if they do cause someone injury or property damage, we know there's coverage. And again, this is the policy where we can be an additional insured on it, and we can actually have rights under that policy. We recommend requiring a bare minimum of $1 million per occurrence, meaning if someone gets injured, the policy will provide $1 million worth of coverage, as well as a $2 million aggregate. That creates a buffer. So if you have one claim that is, really bad and it does, let's say incur $500,000, that's for that one occurrence. We want to make sure there's a $2 million aggregate, and that way there's enough money left in the tank, that's $1.5 million still left if another occurrence occurs. And this is higher than what we recommended as minimums in years past. Before, some minimums would be as low as $500,000 per occurrence. The reason it's being bumped up is because we're seeing a lot of, we call them nuclear verdicts that are awarded by juries. So let's say someone slips and falls and breaks their hip. The jury, will award them $11 million plus. And so when one person gets awarded that, the plaintiff's attorney, when they file the lawsuit against you, they're seeing those dollar signs. They're going to want to go after that much as well. So just the cost to settle claims and the amount of money that juries are awarding plaintiffs is just increasing, which is why our minimum recommendation is increasing for that particular line of coverage. For commercial auto, I know sometimes it seems silly that we would require that at all since we don't own their vehicles, but I am seeing a lot of claims recently where people are crashing into buildings, or like the example John mentioned, they're striking pedestrians on your property, and it's falling back on the property owners. And if we can get that proof of commercial auto insurance and have their policy information, then when they cause a loss, we can file it directly with their auto insurance carrier, not even involve your auto insurance carrier. And it just makes the process a lot smoother. Again, doesn't provide necessarily any coverage for you, but it does give us peace of mind knowing, well, hey, if they accidentally hit the gas instead of the brake on their vehicle and drive through our front door, we know who to go to and what to do. And unfortunately, that specific example is what we're seeing the most of. And same thing with workers' comp, right? Like their employees are not our employees. Why would we require that? It's because we've seen instances where our clients have hired vendors, they don't get proof of workers' comp, and then it turns out the vendor was not in compliance with state requirements. They did not have workers' comp insurance. And now the employee is suing us saying that, well, it was on your property, there's premises liability, you should be responsible. And now you're being responsible for paying for this person's injury that should be covered under workers' compensation. So that's why we recommend requiring workers' compensation, again, even though they're not your employees. It's just to make sure we have peace of mind of, hey, if their employees get hurt while working on our sites, we know that they have coverage. Now, if they're an independent contractor, they're likely not required by the state to get workers' compensation insurance because technically they have no employees. And so I get asked a lot, what do I do in this situation? And it is a tough one because you are accepting a greater level of risk, right? There's no insurance policy that you can get proof of that says, okay, if they get injured while performing work, I know that we're covered. With that being said, I do recommend adding a clause to the agreement that specifies that this independent contractor is actually an independent contractor. So in writing, they're agreeing, I'm an independent contractor. I understand that, you're not going to be withholding any taxes, that you don't have any insurance for me, that, I am responsible for covering my own medical expenses and my own liabilities resulting from this agreement. And I say that because this happened recently to a client of mine, and they hired an independent contractor, and the independent contractor got hurt and ended up filing a lawsuit against them to recover medical damages for the injury that they sustained while working. And they just did not have an agreement with them that said, they had a work order, they had an agreement on price, but they didn't have anything that said they were an independent contractor. So it ended up being a he said, she said argument. The independent contractor argued that, oh no, they provided some of the supplies, they provided some of the supervision, they technically, I should fall under their workers' comp policy. And again, because it wasn't in the written agreement and there was no written communication back and forth, the insurance carriers ended up picking it up because they didn't want to have to go and fight this in court because they felt like the jury would be sympathetic to the plaintiff if that were to happen. So just to avoid that from happening, just get it in the agreement, spell it out, have the independent contractor acknowledge that's their role and that they're not covered by any of your insurance policies. So moving on now to, these aren't necessarily standard insurance requirements coverage, but maybe they would apply. So if a job is riskier, or if you're hiring a vendor to do a lot of work for you, the 1 million, 2 million limits may not be sufficient. And it can be costly to have that vendor increase their general liability limits to higher than that. But what we can do instead, and what may be more cost effective for them, is to have an umbrella insurance requirement. So if so what that means is if their limits on their general liability policy are tapped out on either an occurrence or aggregate, the umbrella policy will come in and provide more coverage, additional limits.
Hi, this is John
Sorry, that was I think John just got muted there. So the umbrella policy will actually get you greater limits than if you require it. just in the general liability policy. So again, if it's a riskier job, you feel like you need more limits than what's in the GL, this is a good way to do it, a more cost-effective way, likely for the vendor. Another type of insurance that may be required is called professional liability. It's also known as errors and omissions. We see this a lot with service providers. So let's say you have someone coming on to provide psychiatric services for the people that you provide services to. Or on the flip side for property, maybe you have a building with fire sprinklers and you hire a fire sprinkler contractor to come in and service and maintain the fire sprinkler system. Now, losses can arise from both of those areas because of the person's professional judgment, a decision that they made, not necessarily, an accident like leaving a, extension cord running across the room and causing a trip and fall. Most general liability policies exclude coverage if the claim arises because of someone providing professional services. So if a loss does occur because of someone's professional services, how we get that covered is under the professional liability policy. Now, this is one of those policies that's often a claims made policy, not the occurrence based. So this is where we'd want to make sure we have provisions that there is an extended reporting period and that the policy is going to be extended beyond just whenever the agreement is supposed to be. That way we have that reasonable extended reporting period. Another claims made policy is environmental liability, also known as pollution liability. General liability policies also tend to exclude losses that arise from the handling of hazardous materials. So if you do have any vendors, and most likely you're going to be having a vendor that has some type of environmental liability exposure. If you have a water damage incident, like I mentioned earlier, and there's mold and you bring in a mold and mitigation vendor, that would likely be a time where you're going to want to get an environmental liability or pollution liability policy, because if they don't do their job properly, or if an accident arises from that, mold is most likely excluded under the general liability policy, but you might be able to get coverage under the environmental liability. So again, that one's not super common, but if you do happen to work with any vendors and there are going to be hazardous materials involved or any type of risk for pollution incidents, again, that's probably going to be excluded under the general liability. So you want to make sure you get environmental liability coverage. The last three are likely going to be needed, but I did want to mention them just because some religious and nonprofit organizations that I work with have started to do some unique and cool things. So for example, I have a couple of organizations that are starting to do farmers markets and they're letting local farmers come and sell products. We want to make sure that losses that arise from the goods sold are covered. That's where product liability comes in. If you're working with any vendors that are storing information on a cloud service, or they're coming in and working on your systems, you'd want to make sure that they have a cyber liability policy. So if there are any data breaches, or if you don't get access to your servers anymore and your information, and you have a business interruption because of that, that's where a cyber liability policy would come in. And then if your organization has any common spaces that you rent out, I have some organizations that they just have large ballrooms in their buildings or meeting rooms that they'll rent out to local organizations to try and raise more funding for their own programs. Just make sure that if they are hosting an event or some type of party on your premises, that they're not serving alcohol. And if they are going to be serving alcohol there, they need to have a liquor liability policy. General liability often doesn't cover losses if liquor is involved or service of liquor, and it's a great risk. And so if you're going to allow them to do it, you want to make sure that they have some protection there.
Sarah, I'm just going to interject. I had thought that we could get through all of this in 45 minutes. As is often the case, I was wrong when estimating time. So I'm going to have you keep going. I don't know if this is another 15 minutes or 20 minutes, but if you need to leave, anyone who's on the line, just email John or email I, and we'll send you the link to the recording. But Sarah, we'll keep going. And for those of us that can stay, we'll keep listening.
Awesome. Thanks, James. And this, like John mentioned, the slides will go out to everyone. And then if you do need any specific sample language for anything that we've covered, or you have any questions or need it tailored, we're more than happy to work with you guys on a case-by-case basis. So back to the insurance requirements, it's important to require specific coverages to cover risks that may arise from the vendor's operations. You also want to make sure you have adequate limits. And then when listing out the insurance requirements, there are also other things we want to require when it comes to insurance, other than just you need to have these coverages and these limits in place. The big one that we've talked about a lot is additional insured status. Another one is you want to make sure that the coverage is for both ongoing and completed operations. So in other words, there are some policy endorsements and insurance policies that are worded that say the additional insured status only applies to ongoing operations. So once the agreement is terminated, the additional insured status is terminated. We want to make sure that status is both for ongoing and completed operations. We talked about subrogation earlier. The insurance requirements section is where you can put in the waiver of subrogation. So, the vendor's waiving their right and the insurance carrier's right to come after your organization for any claims that they pay. You can also request to have a notice of cancellation. So if you're working with the vendor regularly and their insurance policy is going to get canceled by their insurance carrier, you can actually require the carrier to give you a 30-day written notice of cancellation. That way, you know ahead of time that it's coming, and then the vendor has time to get another policy in place, and then to require proof of insurance for the new policy because their current policy is getting canceled. This is also where we're going to put in that the vendor's policy is primary. Our policies are not contributory, they're excess insurance only, so they're only going to come into play once the vendor's insurance limits have been capped. And this is also where we're going to put in a requirement for the vendor to provide proof of insurance. So this slide has sample language. Typically, our sample language has this paragraph to start. It's going to be followed by a bullet point list of insurance coverages and limits to be required. And then it's going to be followed by our proof of insurance requirements. So this is where we're just saying, the vendor is going to provide this insurance at their sole cost and expense. It's not on you guys to provide this for them. They're required to provide this, and they're going to have these minimum limits here listed below. And that's a key term, minimum limits, because I mentioned those changes to insurance policies that happened throughout the years. One recent one that was made to the additional insured endorsement was that the coverage for the additional insured is limited to what's required in the agreement. So if you're requiring $1 million per occurrence, but the vendor has $5 million per occurrence, if your agreement only requires $1 million, then you're only entitled to $1 million of coverage. You can't tap into that extra $4 million of coverage. So it is important when you craft these insurance requirements in your agreements that you specify these are minimum insurance limits only. And then there's also some sample language on the next slide that is also going to help circumvent that endorsement change. And again, this is also where go ahead, James.
Yeah, so kind of a high level question. So should we be getting these sort of certificates and agreements from all on-site vendors? Like, for example, folks probably aren't going to request this from their auditor or a bookkeeping service. But where do we sort of draw the line with, or maybe their direct mail company? Where do we sort of draw the line with on-site vendors?
Sure. So from a risk management perspective, it would be all on-site vendors. Let's say it is an auditor and they're not actually going to be coming on our site, then you may not need, you're not going to need commercial auto, you probably aren't going to need general liability, and you probably aren't going to need workers' comp, but you still would want to require professional liability insurance, because if you make a business decision that causes loss based off of their professional advice, you want to make sure that there's coverage for that, and that policy would likely provide that. Let's say if FedEx is, coming on site to drop off a package, that one may be more difficult to do. And I will say this too, the bigger the vendor is, the more widespread their operations are, the more difficult it becomes to get into an agreement with them and negotiate the contracts, because they have entire corporate legal teams. And they're willing to lose out on business if you're going to be requiring these certain things. So these are just best practices, but my recommendation is to do it whenever you can. Okay.
That's great. Thank you.
Yeah, absolutely. So in this section, again, you want to make sure that this is where you list out all those coverage attributes we talked about on the previous page. One that we didn't mention was a carrier rating requirement. So some people do add this in, and it is recommended just to make sure that the insurance carrier they place the coverages with actually has a good enough financial rating to where we know if there is a claim, the insurance company isn't just going to go insolvent and not be able to pay it. A lot of times we can trust that the bigger insurance companies like the Nationwides will be able to pay out their claims, but you can actually in the insurance requirements list out your requirements for the financial strength of their insurance carrier. And we typically use AM Best as the sort of rating guru or the basis. They have different ratings based on the insurance carrier's financial strength, the size, how much surplus money they have to pay claims. The example here says, the carrier rating requirement is going to be an A-, which is good. Sometimes I don't recommend going any lower than A-, going into the B's, but that's still better than, let's say a C or a carrier that has no rating requirement at all. And we don't know for certain that they're going to be able to pay out claims if one does come. So I'm not going to go through, like I said, we will provide sample language for all the different insurance policies we covered. Just in this presentation, I'm just going to focus on commercial general liability because this is where that additional insured status is going to come into play. And I mentioned earlier about the endorsement changes. So you want to make sure, of course, that they are naming you as an additional insured, and then add in language that specifies, the coverage for the additional insured is as broad as what is being provided for the named insured. In this case, that's the vendor. And if they maintain broader coverage or if they maintain higher limits, we require that those limits apply to us and that broader coverage applies to us. So this is where it's redundancy somewhat, but we just want to make sure it is clear that insurance endorsement loophole is not going to apply to us. And again, we also want to make sure that it extends to both ongoing and completed operations because there's different additional insured endorsements that provide you coverage for each. We want to make sure you have coverage for both. And then we also have recommended language that says that the vendor's insurance carrier's obligation to defend or indemnify us is not limited to the extent of the vendor's negligence. It's not as common, but some general liability policies will actually exclude coverage if the first named insured is grossly negligent. Insurance policies are really designed to cover accidents. They're not designed to cover someone's intentional misconduct. And that sometimes passes over to the additional insured endorsement. So adding in this language just says, hey, we have these rights. They're going to be independent of anything the named insured does. If coverage is excluded for them, it doesn't necessarily mean it's going to be excluded for us. And then finally, for general liability, some vendors are larger. They have a lot of operations and they have a general aggregate limit. A lot of times that's going to be for the annual aggregate. Like I mentioned earlier, you have your per occurrence limit and then your aggregate. You want to make sure that if that vendor does have an aggregate limit that it applies separately to each service and location. So in other words, if a vendor is doing a job for 20 different organizations, you want to make sure that aggregate limit applies specifically to you, that you have the full $2 million aggregate available to you, and that their $2 million aggregate isn't going to be shared amongst you and 19 other organizations. Okay, so moving on, we talked about some of those claims made policy forms. Again, this most likely is going to apply to your organizations when you're hiring someone to provide professional services, which are most often claims made. This is the sample language that just says, hey, yes, you have this policy in place now, but it's going to extend at least 2 years beyond the completion of the work or the termination of agreement to allow that extended reporting period. Now that should be changed based on your state. If you're a state that has a 4-year, 6-year, whatever it is, statute of limitations, you want to make sure that the extended reporting period covers that time. The 2 years in here is just a sample time period. And you want to make sure that they call it a retroactive date, is no later than the start of the agreement. So a retroactive date on a claims made policy sometimes says, okay, the policy starts today, but we're going to cover claims made going back to this date. You want to make sure whatever that start date is for when claims made is when they started doing work for you when that agreement got entered into. And then again, after we list the insurance coverages and we list the limits that we're requiring, we also want to make sure that we have a requirement in the agreement to provide proof of insurance. This is going to be our only way of verifying that the vendor actually has the coverage in place that we're requiring them to have in place. The most common way we get proof of insurance is by requesting a certificate of insurance form along with the policy endorsement. So you don't want to just get a certificate of insurance. You also want to get a copy of the policy endorsements, evidencing that the coverage is in place. And this here on the slide again is just our sample language, and there's not just sample language for the requirement, which is what's up here. There's also sample language. So a lot of times vendors are saying, okay, well, what language do you want us to have on the certificate of liability insurance? It can be helpful if you give them a blurb of sample language that you want to see. That way, when they go and ask their broker for the certificate of insurance, the broker can read it and clearly see what it is that's being required. So, in this case, in most cases with the general liability policy, this is where we're going to spell out that we're an additional insured on a primary non-contributory basis, including completed operations, and that the waiver of subrogation and the 30-day notice of cancellation applies to all policies. And last note here on the proof of insurance, we did start to add in this language here at the end that says, now I put owner in the sample language, just assuming that they're coming, to do work on the premises that you guys own. Of course, you can, change out that term, but failure essentially of you to demand or insist on delivery does not relieve vendor of any obligation under this section. I saw a claim a while back where there was a proof of insurance, all these insurance requirements, our client never got the proof of insurance. And then the vendor said, well, you never asked me for it. So I did, I just assumed that it didn't, you didn't actually need it. So just to alleviate any of that confusion, we started to add that language in. This is an example of what the certificate of insurance form looks like. Again, Accord is just who is the standard in the insurance industry. We recommend requiring the Accord form just because that's going to be the easiest one. If you send it along to us, this is the form that we work with where we know what to look for on the form. And it's going to spell out who prepared the form, likely going to be their broker, who the insurance carriers are that are providing the coverage, what the limits are, whether or not there's a waiver of subrogation, an additional insured. And then this here, the description of operations section is where that sample language we provided on the previous form will be. And then down in the lower left-hand corner is where they list the certificate holder, so who they're preparing the form for. This should always be your organization. You should always be the certificate holder. But as great as the certificate of liability insurance is in terms of conveying information, it is important to note it is informational only. It doesn't really mean anything. It does not provide you with any guarantee of coverage, does not even guarantee you that these policies are actually in place. And it even says it up here on the form. And I get asked a lot, well, if it doesn't mean anything, why do we even require it? And that is a great question. But having a certificate of insurance is extremely helpful because if a claim does arise, now we have a cheat sheet of, okay, here's the coverages they have, here's who their insurance carrier is, here's who their broker is. And we've tendered claims directly to insurance carriers based on information on certificate of insurance, especially if a vendor goes silent after a claim occurs, they stop returning your calls. Now we know which carrier to go call. Now we know who their broker is to call them. It is important to have it for your files for those reasons. And again, you can check them just to make sure everything you've required is on there. And in good faith, their partner, it should be accurate. It's just a reminder that doesn't hold any weight other than to be notes for your files and kind of help us if we do end up needing to tender a claim to a vendor. And that's why it's so important to also get the insurance policy endorsements along with the certificate of insurance, because you can get a copy of that additional insured endorsement, read it, have it, and feel comfortable. For larger projects, sometimes people even request entire copies of the insurance policy. A lot of times that's not going to be realistic for vendors that you're working with. It's a lot of times more applicable for a large project, like a general contractor doing a renovation of a building or something like that. But do know that if you did want that sound peace of mind, it's not unusual to request a copy of the insurance policy, but the endorsements is what's standard to require along with that certificate. And then just that's everything for the quick run through of everything to include in the agreement. Do want to wrap up with some best practices for vendor management. So I think it's always easiest if you have a vendor packet to use. Most of the times, those vendor packets are going to include a decision matrix. So if you're hiring a vendor for the type of vendor, here's what insurance coverages will require. Depending on the level of risk, here's the limits will require. And this kind of just helps you as you go through and contract with certain vendors to be able to quickly make decisions on what to require in that agreement. And the vendor packet should also have a template third-party vendor agreement that maybe you just have the vendor sign, or at the very least, just a template indemnification clause and a template insurance requirements clause. Then you can take the vendor's agreement, kind of delete their risk transfer clauses and just copy and paste yours in to make sure that your preferred contract language is always being used. I think it's more helpful to have those templates as a base rather than having to go through and edit every single contract every single time with vendors, just because we're humans and it's in our nature to miss something and potentially leave a key requirement off. So just being able to copy and paste your insurance requirements into the vendor's agreement is going to save you a lot of time and eliminate the risk of potentially missing something. Another best practice is, of course, enter into the agreement, verify that the insurance is in place. But it's also important to make sure you continue to do that throughout the life of the relationship with the vendor. And of course, you want to monitor the performance of the job that you're hiring them for. But you also want to make sure that if it's a multi-year agreement, let's say that you're working with this vendor and you plan to use them for 5-10 years, you want to make sure every year when their policies are expiring that you're getting the new policy endorsements, you're getting the new certificates of insurance to make sure that they're continuing to stay in compliance with throughout. Another key recommendation is to maintain copies of everything: the contract, the certificates of insurance, the vendor's license, any written warranty that they have, the plans and specifications. All of that should be documented. All of that should be in the vendor file. Like I mentioned, claims can happen years after the fact, and nothing is worse than if a claim happens and the vendor should be responsible for covering the loss, but now we don't have the contract anymore. We don't have their certificate of insurance anymore. We threw it away. I know it can seem excessive to keep these documents and these files for years, but it really is a key risk management tool, because if something does occur, again, you're only going to be thankful if you end up needing it. But if you do end up needing it, you're going to be very grateful that you have all that documentation and able to transfer that claim to that vendor, because you did a good job keeping documentation. And while it's not necessarily risk transfer to have the written warranty and their plans and specifications, not every vendor relationship is going to go well. Unfortunately, they may not live up to expectations. They may, do work that isn't adequate and causes further damage. And if they did not adhere to their responsibilities, or if there should be work covered under the warranty, we want to make sure we have all of that in one place, so we can be able to go to that vendor and make sure that they're being responsible for any damage or losses that they caused. And with saying all of that, I did want to circle back on one point I forgot to make earlier. So James had mentioned some vendors may come on and do work for free. You should think about with those vendors, whether or not it's better to call them a volunteer than a vendor. Because if they're coming on and performing volunteer services, then we can move away from these traditional contracts, have them sign a waiver of liability specific for their volunteer duties, have them adhere to the volunteer safety program. That may be a better category to put them in than vendors. Now, if they are doing, more extensive work, such as, repairing a roof or something that has a much higher level of risk than maybe just coming and painting a wall, then we may want to revisit a more formal contract and revisit some insurance requirements, especially if they're performing professional services, even if they are doing it for free. But again, if someone is providing a free service and you just don't feel comfortable asking them to indemnify you or having them provide you with insurance, it may just be better to put them in the bucket of volunteer, get that in writing and have them sign a volunteer waiver rather than considering them a vendor and having them sign a vendor agreement. And with that, I'm so sorry I threw so much at you guys, but again, we'll have these slides for you to reference that we'll send out. And if you do need we'll send out some sample language for the other coverages and indemnification clauses. But if you do need anything or questions about a specific contract, we are here to help. We're here to work with you guys to make sure that this risk gets transferred. And I've started to put this, I know it's a cheesy saying, the ABCDE, always be careful, document everything, but I have started to end every workshop and presentation I do with this, just because whenever there's good documentation being done, it is always a blessing, and it makes our lives so much easier. And I have yet to come across a situation where someone says, gosh, I wish I would not have kept that documentation. That have not seen that happen yet. Of course, never say never, but for the most part, making sure that you're being careful about documenting everything and maintaining that documentation is going to be a huge help to your organization. And with that, I will pause if James or the group has any questions.
Sarah, it's John. I just wanted to ask, like, I'm putting myself in the position of some of the people on the line. They've never thought about vendor contracts. They've never thought about certificates of insurance. What would be step 1, 2, and 3 that you would say to begin down this path, with step 4 being loop in John and Sarah?
No problem. So step 1 would be to review all of your current agreements with vendors, if you do have any, to see what's in there. If there are no agreements at all, then step 1 would be getting either a template agreement, like I mentioned earlier, or just getting a template indemnification and insurance requirements clause, and then letting the vendors know you want to enter into a written agreement. A lot of times vendors are going to have their own template agreements, so they'll send that to you via email typically, and then that's where you would go through, read it, and then make sure that your insurance requirements are included and your indemnification clauses are included. That would be the best way for the existing vendors. And again, moving forward, I still do think the best step is to get that template language in, and that way you can plug it and play moving forward.
Awesome.
Yeah, and again, I know there's a lot, and I'll also send out a template matrix for the decision matrix that I talked about earlier. That's, for this type of vendor, we want to require these coverages and these limits, because I think that will make it easier to decide, because sometimes you don't know what you don't know, and you're not sure what would be excluded under certain policies for this vendor's operation. So again, it's just a template. It's just a general best practice. Every vendor is going to have unique operations. Every state is going to have some unique risks. So it does need to be gone through, and tailored, but getting at least that template decision matrix down, so we know the basics are covered, and getting that template language that you guys can use moving forward, or take the existing agreements and revise them, because every agreement can be revised. That's what's, it's important to remember that just because you're in an agreement with a vendor doesn't mean you're locked into that for a lifetime. You can revise that agreement. You can get your insurance requirements and your indemnification protections in there.
Fantastic. I am not seeing any more questions in the chat. I know I got one question in my email, and may get some more, but Sarah, on behalf of our team and the Citygate Network Insurance Program, thank you so much for your time and your expertise. I think this was really helpful, and we will look forward to doing this again in about a month. Invite and notes forthcoming, but I'll stop the recording at this point, and thank you again.
Awesome. Thank you, James.